Welcome back to today's video. We've got a couple of sovereign citizens to cover across multiple court appearances. First up, we head to Michigan, where an alleged American state national tries the classic scam claiming that the court only loaned money to his straw man, so the real living person isn't responsible for paying it back. Let's dive in.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared, and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just said, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe. I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
So this actually reminds me of the time a sovereign citizen tried to subpoena every single voter in Harris County, yeah, all 5 million of them. And just like that nonsense, this guy is also about to be denied access to Chase Bank's entire accounting records.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owed $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
That's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
Chavez, you're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender, and they borrowed from me.
This is basically him saying, my 2-digit IQ matches my credit score, without actually saying it. That's your first clue he's a sovereign citizen, most likely of the American state national variety. These geniuses honestly believe that every time you take out a line of credit, the U.S. government secretly deposits money into the bank's treasury. So when the bill comes due, they think they can just wipe out the debt using some made-up secret account that doesn't actually exist.
What did they borrow from you?
My personal security, which I'm entitled to.
No, I'm not buying that. No. Listen
Okay.
to me. Listen.
It's not about. I haven't. This. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You
Is
took
that-
a credit card out. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card. And you didn't pay on the card. They don't owe you anything.
So So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was gonna file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. Okay, 1 second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay,
The clerk's indicating.
I will get that out right
summary
away.
disposition.
I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set.
We're all right, so this case is basically wrapped up. They've scheduled a hearing for the motion for summary disposition on January 9th, and of course, I'll be covering that for you. But before we move on to the next crayon muncher, the smooth brain actually had another appearance on the very same docket, same nonsense, just with a different credit card company.
All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of, I talked to them in the chat, they confirmed it. And I have they gave me a bill credit for inconvenience, so that's why I wasn't able to attend, because I was having problems with the internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So, here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
When a motion has already been ruled on, but one party wasn't able to attend, especially if that party is pro se, the court may allow what's essentially a redo of the hearing. But for that to happen, two conditions need to be met. First, there has to be a valid reason for missing the original hearing. Since this was held over Zoom, a lost internet connection counts as valid in the court's eyes. Second, the party must present a meritorious defense.
Okay, all right, here's what we're going to do. I'm setting a date. So what, do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
I'm sure you spent all day carefully drafting those affidavits on your favorite piece of construction paper. But maybe you missed what the judge actually said. You already filed your answers, and in doing so, you failed to dispute any of the plaintiff's claims. That was more than enough for the judge to rule against you. And as for your demand for due process, congratulations, you just got it.
Motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
and a judgment in the amount of what is claimed in the complaint, $4,378.29 will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set.
Evan, do you want me to make it a bit more savage roast style, or keep it casual and snappy? Voice a perfect seg. And now we move on to the next sovereign citizen, who's about to learn the hard way what happens when you refuse to identify yourself at a formal hearing that you personally request.
All right, we're all set. Thank
I
you,
don't have no
Mr.
words.
Mr. Arnold, I ruled against you.
I have
am allowed
evidence.
to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
And earlier, you claimed you were appearing on behalf of the defendant as his attorney, but surely you realize you can't represent anyone, not even yourself, without a valid bar number.
Mr. Moore, you can come forward, sir. Yeah. Oh. Okay. Are you Sherman Moore?
I am not.
You're not. Okay. And so are you appearing on Mr. Moore's behalf?
Yes,
Okay.
I am, and yes, here for that matter to handle the matter that's at hand.
Okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay, so you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as a beneficiary executor for the said name.
So let me guess, you're the beneficiary of all the perks tied to that name, like if he hits the lottery. But somehow you're not responsible for any of the consequences, like if he breaks the law. When you think about it, that actually sounds like a pretty convenient way to live.
Okay, before I respond, let me see if the city takes any position. Mr. Gunderson, is the city taking any position on the representation of Mr. Moore in this matter? I don't even know if you're appearing on behalf of the city in this matter.
Good morning, Your Honor. Will Gunderson, prosecuting for the city. Your Honor, the city does typically appear for the contested hearings in which officers have been subpoenaed.
Was an officer subpoenaed in this matter?
Yes. Your Honor, the officer is present. Officer Berglund is here. Your Honor, my position at this point is to request a short continuance in this case. The basis being I rely on the Judicial Information System, or JABS, review that information relevant to the particular case. Within the last 20 minutes, JABS database has gone down. Oh,
And
I see that now.
do you take a position on the representative of Mr. Moore appearing in his stead this morning for purposes of the hearing?
Your Honor, ultimately, the city would defer to the court on whether or not the individual is present is allowed to act on behalf of the defendant. To cut to the chase, Your Honor, this sounds like it might be a sovereign citizen type of situation. I don't know if the individual that is seated here is in fact the defendant, or if he is a completely separate person, separate and apart from the defendant that was pulled over at the time this incident took place. So that is a red flag, so to speak, or a question mark that does get raised in the city's mind, for which the city does believe that a further inquiry by the court may be appropriate. But ultimately, Your Honor, with regards to any representation, city will defer to the court.
All right, thank you, Mr. Gunderson. So, sir, I'm going to ask you to identify yourself for the record, please.
I am one of the people.
I'm sorry?
One of the people.
Okay. Are you or have you been previously named or identified by the state of Washington as Sherman Moore?
I am not Sherman Moore,
Okay.
the entity in which you speak of.
Okay. And do you have any relationship to Sherman Moore?
I am just the beneficiary of that name.
Even the prosecutor has already identified himself, and the subpoenaed police officer is sitting right there in the courtroom beside you. So, if you're looking for the verified complainants, I'd say you found them about as close to the shallow end of the gene pool as they're ever going to get.
Okay. Well, the problem that we have here is that at this point, based upon the record that I have before me, sir, you are not authorized to represent Mr. Moore as an attorney in this matter because you are not a licensed attorney by the state of Washington. And at this point in time, based on the record, Mr. Moore has not appeared in...
Oh, he's right here, sir. Sherman Moore is right here. The name in which you speak is right here, sir.
Well, that, for the record, you're holding up a piece of paper.
Yes, the document, Sherman Moore, the entity in which you speak of, and one in which you this court intends to charge. So I am just the beneficiary of said entity. That is all. And that's why I'm here. So basically, I'm trying to find out the nature of said charges that pertain to that name.
Sure, certainly.
Is this a criminal or a civil matter is what I'm trying to figure out here, sir.
This is a civil matter. So Sherman Moore, or an individual identified as Sherman Moore, was issued an infraction here in the city of Lakewood on September 5th, 2024, and was ordered to respond to the issuance of that infraction, which it appears that he did, and requested a contested hearing in which he is asking to challenge the evidentiary sufficiency of the information relied upon by the issuing officer who issued the infractions or the issuance of those infractions. But by requesting that hearing, Mr. Moore, or the individual who was issued the infraction named Sherman Moore, indicated that he would appear in person as a living person here in court. And the problem that I have at this point in time is that based upon the record that I have before the court, Mr. Moore has not appeared as a living, breathing human being in this court in response to his request for a hearing.
I am simply just a man on the land that is here on behalf of that name as the beneficiary for that name.
I understand that. But at this point,
There is a claim being made, so therefore, like I said, I'm just here to understand the nature. You say it's a civil, so where is the verified complainant for said charges?
Who could have guessed that if you don't actually show up for your court date, you're guaranteed to lose? The best part, though, is that after the judge wrapped things up and left, the sovereign citizen suddenly had that moment of realization he'd just finished playing the mess around and find out game. And he definitely found out.
the verified complainant is the city of Lakewood, represented by the attorney on behalf of the city, who is seated in the courtroom to your left, appearing down to my right. And Mr. Gunderson, I'm just going to ask you to formally identify yourself for the record.
Thank you, Your Honor. Will Gunderson, prosecuting for the city. I am licensed to practice law in the state of Washington. My bar number is 46991.
So the plaintiff in this case is the city of Lakewood. They are appearing here this morning through counsel, or this afternoon through counsel. It also appears that the officer who issued the infraction to Mr. Moore is also present in court in response to the subpoena that was issued for his appearance. It appears that the only individual who has failed to appear for this hearing is the respondent, Sherman Moore. And so at this point in time, with the matter having been on the calendar at 10:30 a.m., it's now 12:04 p.m. Given that Mr. Sherman Moore has not appeared in person for this hearing, pursuant to the rules for infractions in Washington courts, the court will find that Mr. Moore has failed to appear and will enter a finding of committed to each of the 5 infractions. And I believe that concludes our court's calendar for today. So thank you all very much. At this point in time, the court will be at recess.
Understood, Judge.
Oh yeah, I'll do it in the, yeah.
All right. Court is in recess.
No, you did have the opportunity to cross-examine the officer. That's the whole reason he showed up. Well, technically, Sherman Moore had that opportunity, but as you yourself said, Sherman Moore is just a piece of paper. And unfortunately, for you, pieces of paper don't have mouths to identify themselves in court, nor vocal cords to cross-examine witnesses. Looks like you didn't think that one all the way through, did you? Alright, that's where we'll wrap things up. If anything new develops with this guy, I'll definitely keep you updated. If you enjoyed the video, hit that like button. If not, go ahead and hit dislike. Either way, drop a comment down below, and don't forget to subscribe with notifications on so you never miss any of my content.